I am of the honest view that the split 2-1 decision of the Court of Appeal, far from confirming Dr. Ayene's position that the case was flawed, was erroneous, and the Republic's chances of having same set aside by the Supreme Court was very high. If Dr. Ayene was convinced that his position would prevail on appeal, why did he not allow the appeal to run its course for a vindication of his views? What did he or his former client, Dr. Atuforsen, stand to lose by the determination of the appeal by the Supreme Court? Ladies and gentlemen, I observe that the real reason for discontinuance of the appeal by Dr. Ayene was that he did not wish to deepen the woes of Dr. Atuforsen any further. Republic versus Ofusuampofo and another. Dr. Ayene did not advance any reason whatsoever for the withdrawal of this matter, save that he was on record as counsel for the defense. I have already pointed out above the absurdity of such a position, and I will not recount. The self-serving nature of Dr. Ayene's decision is too apparent for the people of Ghana to see. Republic versus Collins, Dauda, and 4 others. The reason advanced by the Attorney General for the entry of no prosecution in the case filed against Mr. Collins, Dauda, and 4 others for their roles in the Sagleme housing scheme is that, in his view, the charges were defective. He claimed that the prosecution wrongly charged the former Minister Collins, Dauda with the offense of misapplying public property, i.e. funds, in the sum of $200 million United States dollars. In Dr. Ayene's view, the prosecution should have taken into account the fact that part of the $200 million was used to construct the houses at Sagleme. With the greatest respect, this analysis by Dr. Ayene portrays a complete misapprehension of the ingredients of the offense of misapplying public funds. The offense of intentionally misapplying public property consists in wrongly applying public property, which is defined under the Public Property Protection Act of 1977, SMC Decree 140, for a purpose other than as lawfully approved. It is different from the offense of willfully causing financial loss to the state, whose defining ingredient is the actual loss occasioned the state through one's willful act. In this case, Mr. Collins Dauda was charged with the offense because he intentionally misapplied the sum of $200 million for the construction of 1,412 housing units instead of 5,000 housing units lawfully approved by a cabinet, the Parliament of Ghana, and the Public Procurement Authority to be constructed. So the question of how much was disbursed by the state during Collins Dauda's tenure as Minister for Works and Housing, or the exact amount spent on the buildings when he was minister, is immaterial. The real question is whether Collins Dauda authorized the application of the sum of $200 million for the purpose lawfully approved for the project, i.e. the construction of 5,000 housing units. The answer to this question can only be in the negative. I say that in any event, if the Attorney General was of the considered view that the sum of $200 million mentioned under the count of misapplying public property should have been $94 million, all he had to do as a good prosecutor, acting in good faith, was to amend the count. The remedy is not a discontinuation of the entire case, especially when that offense of misapplying public property constituted only 1 out of 70 charges filed in the case. What happens to the other 69 charges that Dr. Ayene does not fault and did not talk about? With the greatest respect, the state should be seriously worried if her Attorney General demonstrates such ignorance of the basic principles of criminal law and the ingredients of offense, which border on the protection of state funds or public property. The second factor cited by Dr. Ayene for the withdrawal of the Sagleme case is the alleged failure of the prosecution to charge other ministers who took office after Collins Dauda left office. This is another palpable falsehood. The state charged all those whose roles in the Sagleme housing scheme implied criminal liability. This included Kweku Adjumah-Mensah, who signed and authorized the payment of money and who was John Mahama's Minister for Works and Housing after Collins Dauda left office until January 2017. It also included a Chief Director, Alhaji Ziblim, who was in office until 2017, covering a part of the tenure of Mr. Atachia as Minister, and signed and authorized payment of money. Dr. Ayine raises issue with the failure to join Honorable Samuel Atachia as an accused person in the matter. It ought to be made clear that the prosecution of crime is not an arena to achieve political equalization. A careful check of the facts would have disclosed to Dr. Ayine that Honorable Samuel Atachia never authorized any payment for the Saglame project. Mr. Atachia was rather the one who called attention to the bizarre circumstances of the project and wrote a letter seeking the advice of the then Attorney General, Ms. Gloria Efua-Akufu, in or about 2019 for an urgent termination of the contract, a decision which stopped the state from unnecessary financial hemorrhage. The sum of $5 million that Dr. Ayine alludes to was authorized to be paid by the then Chief Director, Mr. Solomon Asola, and not Mr. Atachia. The decision by the prosecuting team not to charge Mr. Solomon Asola, but rather to use him as a prosecution witness, was because an examination of the record showed that Mr. Asola, in truth, tried to save the Saglame housing project from total collapse. The sum of $5 million was authorized by Mr. Asola to be utilized for the project, to save the project. Further, he assisted in shedding light on the relevant facts of the project. Hence, the prosecution's decision to use him as a prosecution witness. Prosecution of Dr. Johnson Pandit Isiama. The narration given by the Attorney General about why he is continuing the two different cases against Mr. Johnson Pandit Isiama again disclosed a litany of untruths, half-truths, and a skillful manipulation of the fact. Be that as it may, as it is with any manipulation of fact, the truth is always laid bare on being subjected to careful analysis. The first case involving Mr. Dr. Johnson Isiama Pandit, or Dr. Johnson Pandit Isiama, is the Republic versus Kwabena Dufo and others, the Union Bank case. This case involved an approval by Dr. Johnson Isiama of the sum of 450 million Ghana cedis for the benefit of Universal Merchant Bank, UMB. Part of that sum was 300 million Ghana cedis, which was an unsecured facility approved by Mr. Johnson Pandit Isiama for UMB for the benefit of Union Bank Ghana Limited. The sum of 300 million cedis formed the basis of a charge of making approval in contravention of the Bank of Ghana law. The remaining amount of 150 million Ghana cedis formed the basis for the offense of willfully causing financial loss to the state. It is necessary to state that contrary to Dr. Ayene's claim, the sum of 150 million Ghana cedis to date remains unrecovered. I must indicate that I find the line of thinking of Dr. Ayene that simply because an alleged loss to the state is recoverable after the offense has been committed or the charge filed, the offense of willfully causing financial loss is rendered invalid, very strange and insupportable in law. Also, an amount paid in violation of the law, when subsequently recovered, does not clear the person who gave the approval to be made of wrongdoing in the first place. The anchor of Dr. Ayene's explanation for discontinuing the case against Johnson Pandit Isiama is a memorandum allegedly delivered to my good self by attorneys of the Office of the Attorney General, purportedly, as Dr. Ayene stated, and I quote him, recommending that the charges against him be dropped. End of quote. Let me state for the record that, to the best of my knowledge, no such memorandum exists. No such memorandum exists. I do not recall receiving any such memo from the prosecution's division. I challenge Dr. Ayene to produce such a memo for the examination of the public, as he has started saying to the public at a press conference conducted by him as a basis for his impugned actions. Curiously, when probed further on that issue in the question session of the press conference, Dr. Ayene claimed that I might have disagreed with the memo, and that is yet to know the exact reasons I made, or the exact comments I made on the memo. This is bewildering and casts grave doubt on Dr. Ayene's assertion that a memo was presented to me on the issue. Will my comments on the position I took on the memo not be expressed on the memo, as is usually the case in every public service institution? How can Dr. Ayene see the memo but not see my comments in the memo? Clearly, the Attorney General set out to throw dust into the eyes of the Ghanaian populace who in his view are a bunch of unethical people. Ghana deserves better than the tales of Dr. Ine. Assuming for argument purposes that a memo was prepared for the consideration of the former Attorney General by some state attorneys whose ranks the current Attorney General does not specify, and on a date he does not indicate, is such a memo, I ask, binding on the Attorney General? Is the view of the state attorney binding on the Attorney General? Dr. Ine himself alleges that he had some discussions with the DPP before withdrawing the cases in question, and that where he disagreed, he made it known to the DPP. Was the DPP's view binding on Dr. Ine? I ask. I further ask, was it not his view, Dr. Ine's view, of the charges he withdrew, which prevailed? If Dr. Ine could form a view of the charges he withdrew from the court, in spite of what the DPP told him, how can he castigate Godfrey Dame in the media for whatever views Godfrey Dame took on the memo allegedly presented to him by some state attorneys who Dr. Ine cannot name, on a date he cannot specify, and affecting some accused persons, again, he could not specify. And I say this because there are 6 accused persons in the matter. The question is, did the memo touch on all the accused persons? Dr. Ine fails to indicate. I say that Dr. Ine should, with the greatest respect, be bold to accept full responsibility for his action and withdrawing and filing no prosecution in all the cases, rather than purporting to blame former Attorney General for his decisions. Republic versus Johnson, Pandit, Isiama, and 5 others, the Unibank case, the UT Bank case. Dr. Ine lumps up the 2 cases against Johnson's Isiama and contends that the alleged memo presented to the former Attorney General, my good self, which discussed the amount of 450 million Ghana cedis, the subject matter of charges against the gentleman in the Unibank case, also covered the UT Bank case. This is another falsehood. The sum of 450 million Ghana cedis was in respect of only the Unibank case. The UT Bank case involved the grant of approval by Dr. Johnson Isiama of 460 billion Ghana cedis facility to UT Bank in violation of a single obligor limit. Be that as it may, it suffices to note that Dr. Ine provides absolutely no justification for a withdrawal of the charges in the UT Bank matter, save the allegation that an alleged memo was presented to me. It is also important to note that the Attorney General conceals the simple fact that the prosecution had closed its case in the UT Bank case. Thus, by virtue of the notice of withdrawal filed by the Attorney General, Dr. Dominic Ine, Johnson Pandit Isiama was acquitted and discharged of the crimes that he had been charged with. Dr. Ine therefore secured through the back door a whitewash and clearing of the sins of Johnson Pandit Isiama forever. Republic versus Stephen Opuni and 2 others. The reasons given by the Attorney General for the withdrawal of the case against the 3 accused persons in the Stephen Opuni case and the consequential whitewash and cleansing of sins through an acquittal and discharge again recount the misconceived perspective of defense lawyers on the charges. That case involved the loss of 271 million Ghana cedis to the state. Once again, the media would observe that the Attorney General only presented to the public the series of stories that had formed the line of defense of counsel for the accused, but completely abandoning the formidable case built by the prosecution. The Attorney General completely disregards the fact that the prosecution had been adjudged by all the courts in the Superior Court's architecture, the High Court, Court of Appeal, and the Supreme Court, as having established a case for the accused persons in that Opuni case to answer. Indeed, Dr. Opuni had closed his case. Saidu Agungu had called about 10 witnesses. Dr. Ine, in the face of the holdings of the various courts, that there was a case for the accused persons to answer in respect of the over 27 charges filed in the Opuni case, proceeded to embark on a scathing attack on the work of the prosecution's division of the Office of the Attorney General, over which he is now superintending, as a ruse to justify the withdrawal of the case. The simple question that begs for answer is, why would the Attorney General, who is supposed to be acting in the interest of the Republic, be arguing strenuously in favor of the Defense Counsel and against the Republic, when all the Superior Court had stated that Dr. Opuni and 2 others had a case to answer. If the new Attorney General was of the view that the accused had a strong case and would be acquitted, why did he not wait for the accused to establish this through a trial? Is it the case that counsel for the accused told him, after his extensive discussions with them, that they were not sure of securing the acquittal of their clients, and therefore they would prefer the Attorney General to bail them out through a withdrawal of the charges? Fellow Ghanaians, in purported rationalization of the government's decision to withdraw the Opuni case, the Attorney General most bizarrely attacked the integrity of a retired Justice of the Supreme Court, Justice Clemens Onyenigwa, and the Honorable Chief Justice, albeit unjustifiably. Dr. Ayine claimed that a perjury application filed by Dr. Stephen Opuni against a witness was not heard by Justice Onyenigwa, and that, in his words, this is most unacceptable. Regrettably, this is another falsehood, Dr. Ayene's press statement. The trial court ruled on the application. The applicant proceeded to the Court of Appeal by filing a notice of appeal. I repeat that the tendency of an Attorney General to make untruthful allegations against the prosecuting team and judges sitting on cases being prosecuted by his office is highly unprofessional. What we see, and this is exactly what we see from Dr. Ayine 3 weeks into his tenure. His actions constitute an attack on the very office he is now head of. Dr. Ayine stated further in his press statement, and I quote, "When in accordance with law and practice, Justice Anochi Jima decided he was going to hold a de novo trial in the same Opuni case, he was instantly transferred to Kumasi, and the case was allocated to a new judge who then proceeded to adopt proceedings," end of quote. This is another plain falsehood and a rehash of the unfounded allegations made by NDC commentators in the media space. If Dr. Ayine had taken pains to examine the file in the Opuni matter, as he should have done, he would have found that it was not a new trial judge who adopted proceedings for the trial to continue. The then Attorney General, my humble self, was compelled to file an appeal against the order of Justice Anochi Jima for the proceedings to start de novo or afresh after they closed the prosecution's case and the defense had opened their case. The Court of Appeal allowed the Attorney General's appeal and ordered that the proceedings be adopted before the trial court. It took about 3 months for the appeal to be heard and determined. Before the conclusion of the appeal, the Honorable Chief Justice, in exercise of her powers under the Constitution, at a time that the proceedings in the Opuni matter had effectively been stayed due to the pendency of the appeal at the Court of Appeal, transferred the trial judge, Justice Anochi Jima, to the High Court, Kumasi, at the time that Justice Anochi Jima indeed had not even started hearing the matter at all. The display of unfamiliarity Ladies and gentlemen, in conclusion, I say that I deem the press conference hurriedly assembled by the Attorney General, Dr. Dominic Ayine, as a knee-jerk reaction to genuine concerns raised by well-meaning Ghanaians on the attempt by the NDC government to whitewash the crimes of persons who served in the NDC government and, as far as the law would allow, clothed them with perpetual immunity from being prosecuted for crimes committed against the Republic of Ghana. The posture adopted by the Honorable Attorney General threatens to undermine Ghana's democratic and good governance structures. I am, however, reassured by the fact that Ghanaians are discerning enough to discover the illegitimate motives for the discontinuance of the cases in question. The President, through his Attorney General, has, in a spectacular fashion, become the clearing agent to indemnify their allies who have duly been put before the court for commission of crimes. Thank you very much. God bless us all. So, I'm open for questions. Hey. So, And my deputy attorney general, my deputy is very skilled and proficient in the three language. Yeah.
Yeah, so.
Yes, Michael Ado, I work with Metro TV. I would like to find out from you what's your inherent fears for this country and the jurisprudence, considering the fact that your successor has discontinued some of these high-profile cases, and what different will you have done putting you in his place?
I'll just take it now. I'll take it now.
My name is Samson Ajiman. I work with CTFM Channel 1 TV. So Dr. Dominic Ayines Presser has received commendation because he decided to give reasons for entering nolli prosequi. Your office argued that the Supreme Court in the Gregoria Foco case. First, what is your view on that, on this approach? And second, on the issue of the Atuforced matter and your alleged conduct with respect to Richard Japa. Even though the High Court judge didn't find any evidence with respect to you asking Japa to testify in a certain way, questions have been raised as to why the Attorney General would speak to an accused person without his lawyer. And second, there were portions of the tape where you sought to suggest that he tell the court that he was unwell for the purposes of securing an adjournment. And these issues, people believe, are unethical on your side.
My name is Benis Besa, I write for the Chronicle. I did not get much of you on the perjury case in respect of the coco matter. So if you can give us what the issue was about, especially what the court said and what the Supreme Court also ruled on it, if I heard you right. Yes.
Right, okay, so I think the first question for the gentleman, what are my fears for Ghana's democracy as a result of the entry of no-prosecution and withdrawal cases? First of all, I look at everything from the perspective of public accountability. It's very important that there's accountability for all officers who hold offices which are deemed to be public trust. So if you occupy a public office, you're supposed to be a trustee of public power and authority. And therefore, once you have no difficulty at all accounting for one's stewardship. And so when persons are prosecuted for specific financial crimes and all, it assumes a greater importance because indeed it borders on the use of the public purse, which they are supposed to be trustees of and what have you. Therefore, as far as I'm concerned, there ought to be a determination of the merit of the offense that the person has been charged with. Counsel for the defense and say that the accused person ought not to answer. And even impliedly confer an acquittal on that accused person. It's unconscionable. And I would think that there's actually sufficient basis for a questioning of the provision in the Criminal Offences and Other Offences Procedure Act at 30, which effectively confers on the Attorney General a power to pass a verdict on a crime that has been that a person has been charged with. But effectively, if that's the case, then it means all an Attorney General should do, especially, I had been a holder of the office, I can cite myself. So various allegations have been made against certain ministers, maybe without any basis at all. I just can collude with Minister A and say, Minister A, let's quickly file a case against you in the courts of Ghana. Once the case has been filed, we call a few witnesses, close our defense, and then close our case, call upon the accused person to open his defense. Once it starts, then I enter a withdrawal, and the person would have been acquitted. And there cannot be a reopening of that case, because once the person has been acquitted, it ends the matter. I think it provides basis for sufficient abuse, especially in all these cases. We saw there's a case that had been made. The court held that Stephen Opuni was a case for him to answer. Stephen Opuni and two others. They went all the way up to Supreme Court. They did not succeed. Same happened in Ernest Thompson. Some count, the court said indeed there was a case for him to answer, as well as Ofuswampo. Ofuswampo, the same day that Atufosin was acquitted by the Court of Appeal, the same panel actually held that Ofuswampo had the case to answer. And subsequently, the Attorney General comes less than a year and says the person has no case to answer. So that's my view. It provides basis for abuse, and indeed, you must look at it from the point of public accountability. An Attorney General, by the exercise of such powers, can effectively shield members of the public from public accountability. Then, commendation by various persons for a press conference by Dr. Union. I mean, yes, the Opuni, the Agogo Afoku matter. So we must make a distinction between legal principles of law and what may be allowed. I mean, or what may be proper. So in the eyes of the law, the exercise of the power of no prosecution is not subject to questioning at all. So when the Attorney General contends in court, which I did when I was Deputy Attorney General in the Afoku matter, that the then Attorney General, Madame Gloria, was not required to account for the entry of no prosecution. That position is correct. But no prosecution is one of the means by which the Attorney General controls the conduct of prosecution. And indeed, I find it a little bit innocuous because it doesn't result in an acquittal of the accused person. It doesn't result in the Attorney General exercising the power to pass judgment on the conduct of any accused person. And no prosecution only results in a termination of proceedings. A future Attorney General who finds merit in the case can revive it and go to court. Indeed, the same Attorney General may even just want to reorganize and come back, which we did actually in the Afoku case. The entry of no prosecution was because they had arrested the second culprit in the matter, whose role was deemed to be crucial. And the then Attorney General deemed it fit to commence proceedings again. And we did it. We didn't just enter no prosecution and whitewash the person's crime. So I think that if the Attorney General decides to open up on the reasons for entry of no prosecution and withdrawal, well, it's something that is permissible, but of course it's not legally the Attorney General is not legally compelled to do that. And indeed, I have on many occasions actually issued press statements, as we all know. The record shows I issued press statements even after the court ordered a mistrial in the Afoku matter and other matters explaining. So it is something that I think that ought to be tolerated and ought to be encouraged and all. But the fundamental question is, what were the motives for the press conference? And as I've disclosed, the motive for the press conference was just to whitewash, was just to explain. He himself knew that there had been a public backlash, there had been a reduction of the goodwill that they thought the NDC had in the beginning by the entry of these withdrawals and all that. The public was really appalled by the manner in which these withdrawals were done, especially when it burdened the use of public funds. And those were really the true motives for the holding of the press conference by Dr. Ayine and nothing more. And regarding Richard Jakpa, yes. So I think that, as I said, the full facts were actually unraveled in the course of court proceedings. The tape was played many times. Even when Jakpa was in the witness box, the tape was played again. I proceeded to cross-examine him. The DPP had early on cross-examined on the allegations affecting me personally because I deemed that no, you cannot be saying things. I said this, I didn't say that, and that kind of thing. It becomes a little bit awkward. So the DPP exercised I told the DPP to conduct that part. In the main cases, the main case affecting Jakpa, I did that. When I was cross-examining, he never even brought it up because he knew the allegations that were made in the media were totally false. The true facts are simple, I've never met Richard Japa anywhere in my life apart from the courtroom and on a few occasions in the house of a justice of the Supreme Court, Justice Yoni Kulendi. And that's because I have never arranged any meeting with him. I mean, Justice Kulendi is a very respected figure in Ghana, a former member of the same firm that I trained, the Kufari Pepenko, and we had good relations before he became a judge. In fact, it's even important to note that the house that I live in, which I bought in 2014, I bought it from Justice Kulendi's client. So we have had that when he was a lawyer, practicing lawyer. And I don't think he even wanted to go to the Supreme Court at that time. So we had that very good relationship and all. So a few occasions, maybe a Christmas party, Easter time, and that kind of thing, I'll go to Kulendi's house. Occasionally, he will call me. He had not seen a long while. Oh, no, I'll come over, and I come over. Then I met him on those few occasions. The interactions we had did not bother anything at all. And indeed, on one of the visits, the very last visit, I knew that he was not well. It's a matter of record. And the record of proceedings in the court showed that even the day in question, his own counsel had called the DPP to arrange an adjournment because he knew his client was not well. And the case came on, the judge asked the lawyer for the accused actually requested that they go into chambers and discuss matters bordering on adjournment. Again, because of the awareness of Richard Japa. And they went, and because of the awareness of Richard Japa, an adjournment was granted. Incidentally, that week happened to be the week just preceding an international arbitration that I had in the United Kingdom. And as a matter of record, you look at all the dates and all. The hearing of the GC net matter, which subsequently the government of Ghana won, was on the Monday after the secret recording by Richard Japa, which was on either the Tuesday or the Thursday. So, and the international arbitration proceedings are so voluminous. And whilst in office, I cultivated the habit of conducting most international arbitration cases ourselves. Myself and my deputy, Dana, Asnaba Dapa, and all who go with other state attorneys and all. So the case against Richard Japa used to come on Tuesday and Thursday. By the Thursday, if you are attending, you are burning a lot of work. Cabinet, National Security Council, court, everything. You must try and do all together. So on the very Thursday, I think it was the Thursday or so, Tuesday or Thursday, I realized I had to really prepare for the international arbitration. Otherwise, the hearing that was supposed to come up the next Monday, I would be very much troubled. So by 12 p.m., by 11 a.m., and the matter was to come at 12 a.m., I realized I was still not really ready or in a position to do my study. And that was a single phone call that I made to him, which was the serious matter of the proceedings. As so I went to call him just to, because indeed I knew he was not well. And that day, as I said, he actually went to court and got an adjournment because he was not well. I just called him in that conversation, not knowing he himself had that illicit agenda and was secretly recording and was saying the things that he got on the tape, which the judge said that those things, if you look at them, came from him and not from me. That's why I said, so you yourself, I mean, you're not well the day I met you. So is it possible? He said, oh, he's afraid because the judge had earlier on, it was a matter of fact as well, issued a bench warrant for his arrest. And so he was afraid to obtain or to apply for excuse from court proceedings on basis of being unwell. I said, well, you can get a medical report. That was exactly what happened. Then he said, well, it's a little too late. He's afraid of the judge. And they went. But when they went, he actually obtained adjournment because it was not well. So the fact of my asking him to obtain medical certificate because it was not well was nothing but factual. Was not an attempt to get him to procure any evidence or anything at all. That is it. And then you asked about why did I speak to him with the absence of his counsel. I've told you exactly the circumstances that led to that, which of course he manipulated and all that. And you will see that Ayini says you're consulting counsel for defense. The question is whether Ayini consulted counsel for defense in the presence of the DPP and all that. clearly, all those conversations that Ayini had with counsel for defense, the DPP and co were not present, acting by himself. These are matters that you can look at. Anyway, I made a question. Yeah, which question was that? Right. On the perjury, yes, so I state perjury application was ruled upon by the judge, and the applicants who were the accused persons, and for that matter, they appealed to the Court of Appeal. So it is not correct that the perjury application was not determined by the court. And it is not even unusual for a trial court to say that the ruling on your application will abide the determination of the main case. If you are aggrieved, you can appeal, which they did. I don't think there's much more to it. Right. Yes.
My name is Mutala Inusa. I work with the EIB group, GH1 TV and Star FM. I want to find our respect to the Sagleme affordable housing matter. The sum in question is $200 million. So Alhaji Collins Dauda and then the four others, unfortunately, one of them is deceased now. In the course of the trial, I remember when the very first prosecution witness mounted the witness box, Reverend Yao Osei. One of the issues that came to the fore was that if you look at the sum of $200 million, charges alone amounted to over $1 million. And therefore, on what basis are you charging Alhaji Collins Dauda to have expended $200 million when charges took away some of the money? Number two, coco board. One of the things that Dr. Ayini indicated was to the effect that prosecution called 7 witnesses to tell their story. Out of the 7, there is no end user, that is the farmer, who testified. Dr. Opuni called 10 witnesses. Majority of them are farmers and end users. Come again. Yes, farmers. Seidu Agongo was in the witness box with its witnesses, and it was also calling end users of little-bit liquid fertilizer. From the prosecution point of view, and the strategy that the prosecution adopted, are these really, is there any of the evidence that the scientists were coming to by way of give witnesses or give evidence vis-a-vis somebody who has called end users of little-bit liquid fertilizer to say that, yes, I built my houses when I used little-bit. Yes, I bought my cars when I used little-bit. If Dr. Ayeni is saying that, continue with this trial, it's a waste of state resources. And for that matter, I want to truncate it. Don't you think it's in order, it's expedient enough? Thank you.
Right.
Hello.
So, first question. Okay.
Okay. So my name is.
Okay, I think the first question is whether why did we charge Collins Dauda for $1 million or over $2 million, where the sum is $2 million. It is never true that we charge Collins Dauda for financial loss in the sum of over $200 million. Indeed, each of the financial loss offenses is built around a specific sum that an accused person can actually be held to have cost. So, Alhaji authorized the payment of certain sums when he was in office. They didn't amount to $200 million. Those form the serious part of the offense of willfully causing financial loss. And as I say, it must be distinguished from intentionally misapplying public property, which is his authorization for the application of the whole $200 million for the construction of 1,412 housing units, when indeed Cabinet, Parliament of Ghana, and PPA had approved that the entire $200 million should be used to construct 5,000 housing units. So his directing wrongly an application of $200 million for a number of housing units far less that had been approved by Parliament and by PPA resulted in his being charged with that offense. So there's really nothing wrong that's been done in the considered matter. Our charges, perhaps you are calculating because each of the counts has specific sums with which an accused person can be linked. And that's it. And then why did we not call cocoa farmers and all that? The Republic of Ghana, when it's prosecuting cases, has the benefit of properly trained scientists who can attest to the efficiency or the efficacy of a little bit fertilizer, which we did. We called scientists from Ghana, Craig, the Cocoa Research Institute of Ghana, as well as sent a little bit and all that. So the efficacy of that has been proven. There's also the opportunity to indicate whether indeed there was a direct link between little bit fertilizer and any increase in cocoa yield and what have you. So I mean, we did not need to call cocoa farmers individually to say, this one we say, oh, my farm, yes, profited from the use of little bit. And this one we say, no, it's not true. Little bit is not right for me. How do you even guarantee whether you use it little bit for? So this is a scientific matter. It's not for, with all respect, cocoa farmers. I have a lot of cocoa farmers in Wenchi. My grandfather had me, so this is not an attempt to look down on cocoa farmers at all. All my uncles are not educated with cocoa farms and all that, so it's not. But I'm saying that it's a scientific process, and we brought scientists and auditors. All right?
So my name is Prince Kudoga from Joy News. I have some few questions for you. Okay. Okay, so Mr. Former Attorney General, how do you
before. The Ministry of Finance may not be the one to conduct pre-shipment inspection, but it is the guardian of the public purse. The Ministry of Finance is the one which pays money to public purse. Even when I was at Angel, many times we sent requests for payment for XYZ, which the Minister for Finance will query. Has not been in accordance with the budgetary limit and all that. So before Minister for Finance authorizes payment, there must be satisfaction of a due process, and that due process includes that there must be a warrant, the basis for the payment. So even an agreement, but it's up to the Attorney General. You asked a question also about OSP, Mr. Ken Ofuriatta. For me, I think it's also important to state that whilst in office, having regard to the requirement for independence of the special prosecutor, I never, on any occasion, interfered with the work of the office of the special prosecutor. If you would notice, there was never a moment on which I met the OSP. I gave him complete independence to do his work. And that's because it's a requirement of the law that we promoted and all that. But of course, the OSP's acts just like those of the Attorney General are subject to law and scrutiny by the courts of Ghana. So if the OSP does anything that will appear to be an overstepping of his bounds, no doubt the courts can call him to order, just like actions of the Attorney General all the time are questioned the courts, and decisions by the President of Ghana are even questioned by the courts. I think that what happened this week between the OSP and Ken Ofuriatta was rather unfortunate, because before a person can be seen to be avoiding the requirement of criminal process, it ought to be an account of that person having been subjected to a process before. And I read of correspondence between lawyers for Mr. Ken Ofuriatta and the OSP, by which, within a period of just about 2 weeks, the OSP had been notified that Mr. Ken Ofuriatta was out of registration. And indeed, he has been out of registration since 3rd or 4th January. So it is not, he went out of registration before the OSP started requesting the attendance of Mr. Ken Ofuriatta. So it is not as if there was a request for the attendance of Mr. Ken Ofuriatta at the offices of the OSP, and then Mr. Ken Ofuriatta traveled out of registration. He left the country 3 clear weeks before the request by the OSP was made. And once it was made, it was not ignored. Ken Ofuriatta responded and stated through his lawyers that he was out of registration. So I find the actions of the OSP, the greatest respect, a bit unnecessary. I felt that could have been avoided, and that maybe lessons will be learned, I'm sure. So that's what I can say. But as I said, you see how reluctant I am. I'm really all the time constrained to make. I never even made any statement at all when I was in office about the OSP, if you remember. The only occasion on which we had to act was when he himself referred the matter to Yoko, and Yoko sought our advice. Of course, even before he was referring the matter to Yoko, he himself had cleared Sisi Adapa of any wrongdoing. So then, white collar crime, yes, taking long to resolve. It's a very important question, and it is one that I sought to cure when I was in office. All the delays in relation to the prosecution of the various financial offenses can never be attributed to the Attorney General. We all in Ghana, we saw the defense, Counsel for Defense, we saw to all manner of trades to delay matters. I can count as many as about 47 interlocutory applications filed by Dr. Stephen Opuni, as well as about 15 appeals filed by them. And I think that it is a situation that the Judicial Service of Ghana or the judiciary must really deplore and not to take a serious view of it. Or many times I complained about it in the media, the delay in the prosecution of these financial crimes, because I recognize that if it is efficiently prosecuted, it could actually it will serve as a very, very positive signal for the country, because it could deter the perpetration of such offenses by persons who hold public office. And therefore, and it's also quite ironic that the NDC would orchestrate such delays only for them to come to power, discontinue the trials, and now, as I hear, even in the social media domain, some commentators will turn around to blame the prosecution for such delays. All the interlocutory appeals were filed by the accused persons. They filed applications from the High Court all the way to Supreme Court, even when the Supreme Court rules, there will be a review and what have you. So, when I was in office, I sought to introduce a bill, which is a Criminal and Other Offences Procedure Amendment Bill, to ensure an expeditious determination of all criminal cases. The bill went to Parliament, got through to a second reading, and then the chaos in Parliament occurred, and the bill was not passed. I quite shockingly heard the new Attorney General express quite a bit of a lack of interest in the bill at his vetting. And I'm surprised, because if an Attorney General is supposed to really be interested in the expeditious determination of criminal cases, he is the Attorney General now. Let's see what he will do about it. And so, and then there was a question by Mr. Kojo Yankson.
Nana Kojo 18.
Of Big C. Yes. Because we act in accordance with due process. The request was made by counsel for the defense. I will say that a company which was not a party to the transaction would offer to pay and the case should end. So the DPP, the Director of Public Prosecutions, wrote back to the counsel for defense that does this, by any implication, mean that you are submitting yourself to plea bargaining? There's a new plea bargaining law which I introduced again when I was Attorney General. Are you coming within the premise of that? And then they wrote back and said, no, they're not coming under that law. And so how are you going to do it? There must be a law which regulates performance or the taking of every step by the prosecution. So on that account, we went through the proceedings and all. But of course, now they are in government. The same counsel for the defense who made those proposals. In fact, even the third accused who brought the proposal is also in government, which is Japa, is in government, so the Attorney General can pursue them for the money. So, I mean, the state should not be, should not suffer at all. Mr. Could you answer this question?
Final question.
No, is it the Attorney General was wrong or something like that? Right.
To say that these people were wrongly prosecuted, so the state has wronged them. He also says that if they seek compensation, he will fight. How do you assess his chances of winning any such?
Very high, because he knows that the prosecution was not malicious. The basis for such a claim by any accused person is when there's malicious prosecution. It's actually what we call a tort. It's a civil wrong. So the fact that a prosecution even fails doesn't mean that the prosecution is malicious. Malicious prosecution is when, without any basis whatsoever, you file charges against an accused person just to chat him up or to intimidate him or to harass him. And that's why you must be careful before you exercise prosecutorial authority. This cannot be the case when many of the accused persons have been held by the court to have a case to answer. Opuni, Pofu, and the Thompson, and all the other cases. It was a Siama, even we had the submission of no case stage when it discontinued. And the bases were clear, and I've showed from what I've stated here that none of the cases can be subjected to the attack of malicious prosecution. So he knows that the chances of his success in those cases is very high. That's because our prosecution was not malicious. So I'm sure that if they file such a claim, it will be dismissed.
Okay, ladies and gentlemen, thank you so much for attending on this press conference. I'm sure that the Honorable Dina Asunaba Dapa will take us through a key treatise and summary of what is happening. And so, Honorable, please wait. Honorable Dina Asunaba Dapa, then we can take it from there.
CP. Wait. Yeah, my name. Yo, and you know me that CP. Say, senior Mira, former Attorney General, a kind, in church, mono dear, a dorsal na, and I'm running tino. Me bonne tofa. Na ya hese press statement ni nyina no e be chama obi ehubi ye di kan say yewura Godfred ye bo adame akire mu say e papa mu pa na nka ni die ntino wa hwe ehu say obeye Attorney General onka eye Attorney General bia adwumadi a odie no ho asem da if he say senior adwuma ni city na say uma Attorney General bia kwan won susu timinya asumdedi ya na adwuma na emra eye Attorney General yenya no fufu eye Dr. Ayini eye ni nyuma na all withdraw cases bi ananse muhu say honorable Godfred Dam ye Attorney General ye DNDC form penifo bi call court no oye free court no din mu nchechemu ba if he say na 4p fa omo se kire ne say eye den na boni etisa sankofo e de anu ti e de o makodan court we free court no o kire mu no na oye na adwen say de di kan oni eye ya judges for be attack wo mu wasa attack yewura Godfred Dam ne de na ese na fata se oba emagana fo nyina behu no kra ewo de ekọ asemi mu ho no nso de no kwadie ni nyina eto ho na no wa be cheche ma no pe no wafa cases no one after the other na de edi kan no se oka se mo hwe hu ya eye ebra MPP aban eba bu wo man no na cases p ni ya ye etia eye MPP for ministers ni appointees na mo amohwa emu bia ni ho a MPP ba aban mu no ye decide say ye be yi sa case na every court na mom MPP for lawyers ejina court eye committee mi aka me am ye cases ni bi mira Godfred Dam so ye sa cases ni bi causing financial loss case ni nyina anye se new Attorney General obaye eye ye ma me Gloria Kufu eyi free court and as Godfred Dam yi free court na mom ye kon wo court e ma broni beka say ye vindicate the right of those accused persons e ma ye di assembly kowie ma court hu say ampa kwa eduna ide abobo sa MPP form penifo nyina no eso ni nyina so bia no enti nanka ye hwe hu say yewura agi awaba fufuri say wo botumi wo gidi pa se NDC form penifo ye de sa kwa edu ahodoi abomo say omo ye innocent nanka with good faith no esa wo twen na wo mo vindicate wo right e show omo innocence senior over the years no ya ye no na enum na yewura agi eye Dr. Ayini na akas impo lawyer for jeche question e ka say wono de wagidi tum pefe say the client no and anybody into one of the obeko akosi eche na no question aye bisa ne say na che say one wagidi say o ye innocent obetimi akom wo mo tokwa no wo court akosi ani no eno de wugya one file no le prosecution na when jai asem ni mu na momo a wususu say wo mo ni gina bia o masem no enye de on bedi fo no eno na wo pese wo boa na pepa o mo bone ho na wo yi o mo fi sa akwa adu no na ye course one yewura Godfred Dam acheche case no ma de di kan pa enu nti yewura agi gina so ye Dr. Ayini say wo yi sansemfo yi bebre every court ni apepa omo bone ho ni clear omo from boni o maye ne say eye internal memo bi wo office of the AG eye krata bi wo office of the AG eye prosecutors omo AG two Godfred Dam for say wonya case ni mu if say eni gina bia na eno ena yewura Dam throw challenge say sa memo bia ni ho sa na etisa yewura Dr. Ayini ema ye hu na etisa so a memo se ni nyina ye nim no so ka Godfred Dam so be kire na adwene wo memo no so am ye hu se me ne mo nya adwene enam sa reasons we enti reasons kwa Godfred Dam so throw wo sa memo no so say ye no krese sa memo bi wo ha o ma ye hu e ho nkosam na hodo kwa edu ni bi wo ha na ebe aduonum nson ebi ye aduoson so wo fa charge back na say we mi hu say defective to say sagleme case no the question is assembly say wo ho ne say other charges na account the one can ho asem to who strike here no kwa out then other charges na account kwa edu na account e de one to aso ne tie mu an say ene ye pese Ghana for ehu ye pese no kre ene intra doc no kre wo yasem ni mu ene intra Dr. Ayini abetwa e wo hanom say na susuampa asama Mira Godfred American said ni giseme wom ni say senior doctor yi ne pese ehu se bi Ghana for ya adwini sa no ente sa na sa wodwene ho atie nsem na okeka ye no eni de yenso ye de aba response na wobɛhu se eye ntro na doctor yi ne ebegina ha na nsane ne ebeka che Ghana for enti mesremo ye de sa press conference ba around say wontie the fact na ni sa lump sum statements na wa make and as to the basis I will use answer ni free on enye no kre ni nyina twato se eye NDC amamwo NDC government eye yewra Dr. Ayine as Attorney General ni tipo nyina ne se boni a NDC fo edi eye corruption a o ma di Ghana fo dwuru eni sika bebrebe a ye hwia no onye na adwene NDC government nye na adwene se obem pinsempese mu na emo obe katakata so ama omo boni no odi a che wo medam ase.
GTV, the authentic and trusted voice of Ghana.
That's the who says zebra crossing here. That's a focus of became zebra crossing. Gina, I was so making sure the car seeing and sign with you.